Well, as promised, Mr. Adeboro Adamson, Senior Advocate of Nigeria, joins me on the news tonight. Thank you so much for joining us on the news tonight, Senior Advocate.
Thank you.
So in looking at this case, what does Nigeria law say about detention limits before a suspect must be charged or brought before a court? In this instance, the case of former Kaduna State Governor and the ICPC interim judgment.
Let's look at what the Constitution says first.
Yes.
We have reference to Section 35 of the 1999 Constitution, which says that every Nigerian citizen enjoys right to liberty of person. And though the right is not absolute, it can be derogated from. There are conditions for the law enforcement agencies to derogate from the provision of 1999 Constitution, that is Section 35. Now, if you look at Administration of Criminal Justice Act 2015, particularly Section 293 and 296, it gives the law enforcement agency the right to apply to a court for a remand order. And the first remand order that the court will grant will last for 14 days, subject to renewal for another 14 days. Now, if at the end of 14, that's 28 days,
Yes.
the law enforcement agency has not concluded investigation, they still have another 14 days. In other words, you have 14 days in 3 places before that right will be exhausted.
But they must go back to the court.
At the end of 28 days, it is right of the suspect to approach court for a bail. And if that particular person meets the condition, the court will grant it. But you see, after the 28 days, it becomes a difficult task for the law enforcement agency to secure another 14 days. That's the third term. Because you have to give compelling reason why you want to keep that person in prison for another 14 days.
For clarification, Senior Advocate, the ICPC has told Nigeria that it has an order for 14 days and not 28 days. The family of the former governor, on the other hand, says, first, the ICPC even lacks the legality to keep him for the first 14 days, but given that 14 days was secured, the 14 days has elapsed.
That was why I was trying to explain to you that if you look at Section 296 of ACJA,
Yes.
Administration of Criminal Justice Act 2015, the law enforcement agency can approach the court while investigating a suspect. And the court order for a remand order will only last for 14 days. Upon the expiration, the law enforcement can approach the court again for another 14 days. If investigation has not been concluded.
So now that the 14 days has elapsed, should the ICPC have told Nigeria that they have gone to court again to secure another 14 days? Because as it stands, what we know is that the 14 days has elapsed. ICPC is yet to tell us they've gone back to court to extend that. And that's why the family is raising concerns.
If ICPC is done with their investigation within 14 days, they will do whatever they want to do with the suspect. Either to take him to court, to charge him to court, or to allow him to go to enjoy his freedom. But if there is need for further investigation, or the investigation has not been concluded, to the extent of taking that particular suspect to court, then ICPC can go back to court again for extension of that 14 days.
Without
for
explanation.
Another 14 days.
Without explanation to anybody. But
no. You see,
yes.
Not the explanation is to the court, not to you.
Not to the public.
Not to the public.
Great.
It's to the court. It's not the public that will grant the application.
Sure.
It's the court that will grant the application. So the explanation you want to offer must be offered to the court.
Senior Advocate, where is the line between legitimate investigation and unlawful detention? Because that is also part of the questions being raised here. And we've seen it time and time again with our agencies. They are accused of keeping suspects without having concrete evidence, and then they just keep doing this. So where do we draw the line? And how do we ensure accountability, that line is not crossed between legitimate investigation and unlawful detention?
You see, our laws have given powers to the law enforcement agencies to investigate suspicion of crime, suspicion of commission of crime. So to that extent, where there is a suspicion of commission of crime, they have the power to invite and to arrest and to detain. But that detention, by the provision of the Constitution that I've cited, Section 35, is to last for 24 hours, where there is the promise of the court is closed, and where it is not, is 48 hours. So this is the constitutional right of the law enforcement agency, and equally the corresponding right of the suspect to apply to court for a bail. However, where there is need to investigate, there is a suspicion, real suspicion of crime, then the law enforcement agency will go to court for another court to remand that person in prison pending investigation. So that is legitimate. But where, for instance, the investigation is frivolous or you don't find anything, you see, the law is clear. You see, for every right that is wrong, or for every damage to every right, there is remedy. And that is why the remedy is there for any suspect who has been arrested wrongly or detained wrongly to approach the court of law for redress. The laws are there to address the situation. So there's no big deal about that.
But do you appreciate the stance of the party, ADC, which former Governor El-Rufai belongs to, when they accuse the government of selective justice? They say for someone of his profile, they have seen, measures given or granted to other people who are of the high profile in the country, giving self-recognition to go or to leave while investigations are ongoing. But El-Rufai is being kept, and they think it's for political reasons, and they say it's selective justice. Do you appreciate where they're coming from?
As far as I'm concerned,
that he's high profile.
My position is this: the law is a leveler, and nobody is above the law. Justice to be done to everybody, irrespective of class, status, or whatever you belong to. And again, he who lives in a glass house must not throw stone.
Why do you say that?
Now, the question is, if you know you're in opposition, and you know you are not clean, why should you begin to make inflammatory statements that's capable of destroying the unity of Nigeria or the national security of Nigeria? So these are the issues. It's not, to me, yes, you can employ the antics of policies to discredit what the law enforcement agencies are doing. But as far as I'm concerned, the fact that A was not caught and B is caught does not create a dichotomy.
Okay.
The law is the law. If you offend, if you break the law, then you face the law.
Adeboro Adamson, Senior Advocate of Nigeria, thank you so much for sharing your thoughts and insights on this story. We do appreciate your time.